Hello, my name is Tamara Arnold, and thank you for taking the time to educate yourself on the fundamentals of estate planning. I know it's not the most exciting topic, but like life or health insurance, it's necessary. You may have a general understanding that estate planning is important for wealthy or older people, but you may not know why it's necessary to have a plan in place to protect your family now. So today I'm going to talk to you about how life and legacy planning can protect your family's legacy and assets and bring you peace of mind no matter what happens. So what is estate planning? Essentially, it's about planning for the unexpected. If something should happen and you or perhaps your spouse die or become incapacitated, does your family know what to do? Who would take care of your children? What happens to your bills, your property, your accounts? How does your chosen person step in to pick up the baton and carry on if you can't? In the next few minutes, I'll answer these questions by walking you through what estate planning is and what it isn't. I'll talk about the essentials you need to cover in any plan, and I'll share real-life examples from my life or my clients' lives to illustrate how important this is. And of course, I'll explain how my firm can support you on this journey and how my process differs from your typical estate planning experience. First, a little bit about me. I'm Tamara, an attorney with over 20 years' experience. My practice over the years has included representing Fortune 500 clients in multi-million-dollar class action lawsuits to soldiers injured in combat, all the way down to couples who have decided they want to divorce in a way that doesn't destroy their family. These days, I consider myself a life transition lawyer, which means my practice specializes in helping guide my clients and their families through life's most difficult transitions, whether that's dealing with family disputes about divorce or caring for aging parents, or protecting your family if the worst should happen. I am my client's go-to personal family lawyer through all of life's twists and turns. My practice, Truce Resolutions, specializes in estate planning and divorce and family conflict mediation. I practice in Santa Barbara County, and I am licensed to help clients all over California. I'm also an active member of my community, and I currently serve as the chair of the Santa Barbara Civil Service Commission. Finally, I'm a mom in a blended family with 4 kids between us. I've been through personal challenges myself, and I'm so honored when I can guide my clients through their own life transitions with grace, grit, and integrity. Okay, let's get to it. Here's the most important questions your plan needs to decide. First, what happens to your assets? Who gets them, when, and how do they pass to your heirs? A great estate plan can also protect these assets so creditors, lawsuits, or ex-spouses can't get to them. Second, who makes financial and medical decisions for you if you can't? Who steps in and how do they find your assets and get access to them? And third, how are your loved ones cared for? Whether that's your children or adults or parents you care for that may have special needs and considerations. And we're talking about who will raise your children if you can't, who will handle their medical care, and how decisions are made to support them financially with the assets you left for them. If you don't have a plan that answers these 3 key questions through legal documents, and you become incapacitated or you die, California's laws will step in to decide these questions for you. So let's first look at what happens if you don't have a plan in place. In California, if you have assets over a certain amount, maybe you own a home worth over $750,000, or maybe you have over $200,000 in other assets, and you become incapacitated or you die, a judge will step in to appoint someone to make decisions for you. And no, your spouse doesn't automatically get to step in. Also, your assets will be frozen until this process completes. This court process is called conservatorship if you are incapacitated or probate if you've died. The court decides where your money goes and who takes care of your family. But that judge doesn't know you and may not make the same decisions you would. Essentially, this court process is a lawsuit that you file against yourself with your own money for the benefit of your creditors who get paid first. Why is it your own money? Because there are attorney's fees, executor fees, appraiser's fees, court filing fees, bond premiums, and creditors' claims. And all of them get paid. Creating a trust as part of your estate plan helps you avoid probate and saves your family tens of thousands of dollars. So now let's get into the details. The first question an estate plan answers is what happens to your assets when you die? And there's two primary ways to answer this question, either through a will or a trust. Both legal documents say who gets your assets when you die after creditors are paid, if any. But the difference is this, and this is a common misconception. If you have a will only and not a trust, the will has to be sorted through in probate court, that expensive process that I just mentioned. A will does not avoid probate. If you create a trust, on the other hand, and your assets are covered by that trust, your relatives don't have to go through probate when you die. A trust is a legal contract where the grantor, you, gives assets to a trustee, who is also you until you die, and another trustee steps in. And those assets are for the benefit of a beneficiary, which are your heirs. Think of a trust like a treasure box. You put your assets in the box so they're no longer technically yours, but they're held there for you. You can use those assets, and then when you pass, your trustee handles how those assets are managed for your heirs. You make all the decisions when you create the trust. The key to remember about trusts is that the trust is the treasure box, but the assets need to go inside the treasure box for it to work, and this is called funding. It requires that your assets be aligned or renamed so the trust owns them, and that's how you avoid probate, by putting the assets in your treasure box. Creating the trust is the first step. Aligning your assets is the next important step, and we see many people think that they're protected because they created a trust, but they didn't actually put their assets inside that trust treasure box. In my practice, we have systems in place to make sure trusts we create for you don't fail because you didn't complete this second important step. So I want to explain how this works in practice with a real-life story. A couple of years ago, the mother of a close friend of mine died with a basic will, but without a trust. Her estate was a house and a money market account, which was valued at about $1.5 million total. She named her daughter, my friend, her personal representative to handle her estate. And even though there was a will, a probate case was required because, as I mentioned, wills still need to go through a probate court. Assets were frozen until the case made its way through court, and the probate fees alone cost the family about $75,000, and the process took 18 months before the heirs ever saw a dime. And during the process, the step-siblings fought over everything because the will wasn't very clear. Now, my friend's mother had good intentions, but she left her family with a mess. And had her mother come to me first, she would have spent a few $1,000s on a custom estate plan, but would have saved her family $75,000, 18 months of hell, and her family would have come together in their grief instead of creating permanent rifts. Without a plan, the court decides for you. The second question is who makes decisions for you if you can't? And here we're talking about incapacity, not death. So if you're seriously injured physically or if you suffer from a mental incapacity. Two legal documents answer this question. The first is a durable power of attorney, which decides who gets to make financial decisions for you and how to spend your resources and care for you. The second is a healthcare directive, where you decide what treatment you want if you're incapacitated and who gets to make medical decisions on your behalf. So if you're critically injured, your spouse may not get to automatically step in, and your family may need to go to court and get a conservator assigned by the judge, all when they may be experiencing the worst moment of their lives. And if your wishes aren't known, they're guessing as to what you would have wanted. To drive home why this is so important, I want to share a story from my life. When I was 13, my mother Marlene, my brother, and I were all in a hiking accident. My mother had the worst injuries. She broke her neck. While she was unconscious, the doctors gave my father a choice: let her go by turning off the ventilator, or let her live as a quadriplegic, unable to move or breathe on her own. Now, my parents had never had the conversation. My mother didn't have a healthcare directive. Afraid of losing her, my father chose to keep the ventilator on, and for a year, my family watched the strongest woman we knew suffer, a prisoner in her own body. A year later, she made the agonizing decision to refuse food for 45 days until she passed away. And I know this is a scary and tragic story, but we know tragedy can strike when we least expect it. That year of suffering could have been avoided. The conflict, the guilt, the trauma, all of it. Her wishes would have been honored if they had simply been written down. This experience, you can imagine, is the heart of why I do what I do. Because life and legacy planning isn't about documents. Underneath, it's about love. It's about protecting the people you love most from having to make impossible choices in their darkest hour. It's about ensuring your voice is heard when you can't speak for yourself. Finally, the third big question is, how are your loved ones cared for if you can't be there? If you have minor children or special needs children, naming a legal guardian is important to give the person you choose the legal authority to care for your children if something should happen to you. In my practice, we spend a lot of time on this. In fact, I have a kids protection plan where we name not only permanent legal guardians, but temporary first responder guardians. We also discuss how you want your assets spent on your children. For example, if your child is 18 and you and your spouse die, they'll get your life insurance, your accounts, and immediate unfettered access. Now I ask you, do you think an 18-year-old will make wise decisions on how to spend that money? Probably not. So I spend a lot of time with my clients talking about how to create protection for your assets so they last. We can even protect their inheritance from a divorce so their ex can't get to them, or from lawsuits if they're ever sued. And my last story today about this happened to my best friend, Holly. She married a widower who had a young daughter, and for years, Holly raised her like her own as a stepmom. When her husband, who had mental illness, took his own life, Holly fought hard to stay in her stepdaughter's life. But unfortunately, after an expensive legal case, the court awarded custody to her husband's mother, and Holly was eventually cut out of her life until the child became 18 and they reconnected on their own. Holly's husband never named a legal guardian for his child, and while Holly was certain he never would have wanted his mother to raise their daughter because she was overly strict and a little bit cold as a mother, the judge wasn't convinced. Naming guardians means your children will be raised in a way you would want if you can't be there. And it's especially important for blended families. Also, most people don't know this, but if you don't name temporary guardians and you don't come home one night, your child could actually end up in temporary foster care until it gets worked out with the judge. Relatives can't automatically step in. So we create temporary guardian nominations, and everybody that you name gets letters and documents so they know exactly what to do if something should ever happen. This is something that most estate planning firms don't do, by the way, but we do. So those are the three main things we address with an estate plan that keeps your family out of court and out of conflict, so everybody knows exactly what to do if life takes a turn. Here's how we support you on this journey. We always start with a life and legacy planning session. This is how we get to know you and your family dynamics. It's a full working session with me where we discuss your family dynamics, your goals, and your assets, and how the law would apply if you don't plan, and what you like or don't like about the state's automatic plan for you. Then I'll help you make an informed and empowered decision about what plan to choose. You can see our fee range here. We offer 3 levels of planning, and you choose your level and your fee based on your objectives and what protections you want to build into the plan. It's kind of like designing a new kitchen where you choose the options. Once you choose the options you want and submit payment, we'll design your plan together in detail. Then I'll get to work drafting your legal documents, and we'll get together again to go over everything and sign and notarize them once they're complete. I'll also guide you to make sure all of your chosen people have the documents they need to step in, all of your assets are listed and organized so they're not lost, and I'll even record what I call a legacy interview. That's an interview with you that's archived on a thumb drive to preserve your voice, your stories, your values, and the legacy you want to leave for your children. It's my favorite part of the planning process and an added benefit to working with me. By watching today's presentation, you already took your first step. So here is your next step. Think about what you've heard and start a conversation with your spouse and family members. I want you to scan the QR code on the screen. You can turn on your phone's camera, point it at the code, and click the link to be taken to a form. Fill out this form and submit it to me, and then we'll give you a call to pre-qualify you for a life and legacy planning session. Once you're on our schedule, we'll send you a little homework so we can learn about your family and your assets. This will be completed in our secure portal, and it's important because the homework allows us to make the most of our planning session and hit the ground running to designing a plan that works for your unique situation. Now, a 2-hour life and legacy planning session typically costs $750. However, if you complete the homework before our session, we'll give the session to you for free. We'll take a $100 deposit to reserve the session on our calendar, which will then apply as a credit toward the plan of your choosing. If what I shared with you resonated, and now you understand why it's important to plan, please fill out the form. Don't keep putting this off because I know life gets busy. I can only serve a few clients a month because this work is time intensive. So get on my schedule as soon as possible. If you want to ask me questions before you submit your form, just go to planwithtamara.com and book a 15-minute call with me. I'll answer any questions you may have. Thank you, and I look forward to getting to know you and your family better as your personal family lawyer.